Hello, everyone, and welcome to Ask a Care Navigator, Mondays with Maureen. Hi, everyone. My name is Maureen Williams, and I'm the Director of Care Navigation here at Four Seasons, the Care You Trust. And we try to create this space on most Mondays to talk about issues associated with living well and aging well, and perhaps how Four Seasons and our other community collaborators may be of service. As always, if you have any questions or comments, you can drop them into the comments box from whichever platform you're viewing, or you can call us at 866-466-9734. Best way to get information about us and to us is also to go to our website, which is fourseasonscare.org. Please spell out the number 4. And I'm so delighted to share, as always, our gratitude to the Van Winkle Law Firm for serving as the title sponsor for this program, Ask a Care Navigator, Mondays with Maureen. The Van Winkle Law Firm is one of the most respected and well-established law firms in North Carolina, providing exceptional legal representation for individuals, families, and businesses in matters of personal law, business law, commercial law, and estate planning matters with whom I particularly interface. And I'm delighted today to have one of our community collaborators from Van Winkle Law Firm with us today. This is Coral Allman. Hi, Coral.
Hi.
Tell us a bit about yourself.
Sure. I'm a partner with the Van Winkle Law Firm, and I do primarily trust and estates work. So 50% of my work is helping people plan for the future, preparing estate planning documents, and then another 50% is helping loved ones who have lost someone as they deal with the probate process, which we're going to talk about a little bit today, or a trust administration process, or both.
Perfect. And I have to say thank you also to Coral. She's on the Four Seasons board.
I am.
For which we are very grateful. That's another
Full disclosure.
Yes. Oh, and full disclosures. Nothing that we talk about today constitutes legal advice. Correct? Anything else for that disclaimer?
Right. This does not constitute the establishment of an attorney-client relationship. This is just general advice, and I strongly recommend that you consult with your own attorney about any specific questions.
Absolutely. We just want to inform and educate.
Yes.
Well, today's topic is wills, trusts too, and as you heard Coral say, this is her specialty.
Yeah.
So tell us about wills.
Sure. So your will is a document that is designed to administer your affairs at your death. So it has no effect while you're alive, which is why you're able to amend it, revoke it, change it however you want,
anytime,
as long as you have capacity to do so at any time. Once you die, of course, you can no longer modify it any further, and that gives guidance to your executor. That it's also called a personal representative in some states, but in North Carolina we call it an executor, who is the person tasked with administering your estate.
Right.
And administering your estate, often called probate, or the probate process, is a court-overseen process where the clerk of court here in North Carolina oversees the administration of your affairs, including payment of debts, taxes, or any expenses related to the administration. The executor has to, what we say, marshal the assets. So if you have an individually owned account, they're tasked with going to the bank, closing that account, transferring it to an estate account.
Got it.
So we're kind of consolidating everything into one bucket from which we pay those debts, taxes, and expenses. And then we ultimately distribute it to our beneficiaries, however the will directs. The probate process is often something clients are very concerned about. I have many clients who come and say, I want to avoid probate. I want to avoid probate. Also many clients who have heard someone on a late night ad say, you need a revocable living trust. And neither of those things are 100% accurate. Okay, just like anything, an ad is an ad and does not mean that it's applicable to you.
No.
So the probate process I talked about is the court overseen process where they determine the validity of the will and they oversee the administration of those things, the payment of the expenses, the collection of the assets, and the distribution.
Got it.
It can be tedious in North Carolina, but there are benefits to probate. Not least of which is what we call the ascertainment of creditors, which is
That's a big
a
word.
fancy way of saying we figure out, do you owe anyone money?
Okay.
And we address those things. There are known creditors. I know I owe on my credit card or this hospital
or
bill,
mortgage or something.
right, or things like that. But there could be unknown creditors.
Yes.
You forgot that you hadn't paid your pharmacy bill, or you hadn't finished that last payment on your old cell phone bill. Okay. So part of the probate process involves us publishing what we call a notice to creditor in a local newspaper. which gives a deadline by which any creditor needs to submit a claim. When they submit that claim, it gives us a cutoff. So we can't have 5 years from now some pharmacy down the street saying, you owe us $35, but we've already distributed everything.
Right.
So there's a benefit there of really making sure we know our whole world of possible debts or expenses within a relatively short period of time. There are also sometimes reasons why we have an estate anyways, which would be to vest real estate. Without getting in the weeds too much on that, real estate is handled differently in the state of North Carolina, and title to real estate vests automatically to the beneficiaries named in your will, but you have to file documents with the court to actually demonstrate that.
And real estate could be as simple as one's home.
One's home, or even a piece of dirt that you inherited from daddy that has nothing on it.
And you just let it set there. Okay, very helpful.
So a revocable trust, which is the thing that people often come to talk to me about, is a sort of a will alternative. You would still always have a will as well. You might also have a will and a revocable trust. If you have both of those things, your will is what we call a pour-over will, which sends the assets to the trust, and the trust does the heavy lifting.
Great.
Okay? So a trust is just a legal document that provides guidance about what is going to happen to your assets. Unlike a will, it does have some effect during your lifetime, but it also has the ability to distribute your remaining assets at your death. And so the way you would use a trust to avoid probate is you would be retitling assets into the name of your trust while you're still alive.
Got it.
If it's still in your individual name when you die, your will governs it. The probate process sends it to the trust.
Got it.
Then the trust sends it out. But if you put it into the trust before you die, it's already there. I don't have to do this piece, right? It's already in my final vehicle, and it would be distributed that way. So a revocable living trust is the type of trust most people are talking about. It's not the only type of trust, though. There are irrevocable trusts, which, as the name implies, have restrictions on how much or if you can amend them. You can always kind of get around it if you were to go to court and file a lawsuit, but that's not a very streamlined process. A revocable trust, you can come in, you amend it, we resign, you can change this, you can take someone out, you can add something in, as long as you have capacity to do so.
That's right.
An irrevocable trust is pretty much set in stone, and there's no amending it. It also generally involves giving up control of those assets to a third party. So if I set up an irrevocable trust, I am no longer going to be the trustee or the person that is administering it. I might say, you're administering. You might be administering it for my benefit, but I don't get to make those decisions anymore. You do. It's a lot of control you're giving up. There are tax benefits to that or Medicaid planning benefits, but most clients, unless they are really, really subject to these concerns, don't like the idea of giving up control. No. Almost no one likes to give up control.
No, I don't.
But there's dozens of irrevocable trusts. Estate planning attorneys love acronyms for those things. So there's ILETs, there's CRUTs, there's CRATs, there's GRATs, there's all slats. I mean, there's so many. And each of them are designed to handle different situations. That being said, the number, I would say percentage-wise, the number of people who are really appropriate candidates for those myriad of irrevocable trusts is extremely small. Okay. The number of people who are maybe appropriate for a revocable trust is more sizable. Right. And the considerations often for whether or not you need a revocable trust is frankly, how much wealth do you have?
Listen up.
Whether or not you want to have those assets subject to the probate process. Privacy concerns. You don't want people to know to whom you're giving your assets or maybe not giving them because the probate process is public. And it's increasingly public because it is now available online. So you can go online and type in people's names and see what their will says. So wealth, privacy concerns, complexity concerns. If your trust has a lot of moving parts and if this, then that kind of clauses, we probably don't want to do that in the court because we have to then explain it with minute detail, how the math works. The other big one is whether or not you own real estate that's again, a property, a house, piece of dirt, beach condo, whatever, lake house. If you own that in another state, that is a strong motivator for having a revocable trust. The reason being, if you don't, I would have to have let's say you own a condo on the beach in South Carolina. Right. But you die here in Asheville. We would have a probate process here in Asheville, and we'd have a second probate
Gotcha.
in Charleston County, South Carolina. We are doubling the amount of work that we have to do when you've died. Alternatively, we have a revocable trust. We retitle at least that South Carolina property into your trust.
Gotcha.
We don't have to have a probate there anymore.
No.
We're just doing a deed to distribute it to whoever is to receive it. So those are sort of the very broad strokes about a will and trusts and all the different types of trusts. But the other thing I wanted to talk about is will alternatives that aren't necessarily legal documents, meaning ways that you can kind of mitigate your probate exposure without, everyone needs a will. That's not what I'm saying.
Let's say that again. Everyone needs a will, please.
If you don't have a will, the state of North Carolina or whatever state you reside in creates one for you. It is almost never what people actually want. It is what the state has determined to be the most fair. What does that mean? Depends on your personal situation, yes. But you can reduce your exposure to probate with things like joint ownership of accounts, which we really only want to do between married persons. You do not want to add your child as a joint owner on a bank account. That is what your power of attorney is for. Okay. Otherwise, if your child gets into a car accident and gets a judgment, the money that you have saved to get you through retirement is now subject to their creditor claims.
I want y'all to hear this.
That's a bad one. Okay.
I want you to hear this.
And it comes up a lot, in part because I have seen some bankers say, oh, it's just easier to add you on the account. And that's not a knock at bankers. It probably is logistically easier, but it creates different legal challenges, including the fact that it could effectively change your estate plan. Yeah. You could also add beneficiary designations on your bank accounts or brokerage accounts. So payable on death for bank accounts, transfer on death for brokerage accounts. Gotcha. Same concept. You fill out a form, you send it to your financial institution, and it says, when I die, this account goes 100% to Maureen, or 100% to Maureen, 50% to Maureen, and 50% to Steve down the street. And all they have to do is they fill out a form when I die, and the account automatically transfers. The thing to remember with this, though, is you want to make sure that you are doing this with intentionality. You don't want your will to say everything gets split 4 ways among my 4 kids, but all of the accounts only name one child. Gotcha. Okay, that beneficiary designation is a contract you've established with the bank. It takes precedent. Yeah. Your other 3 kids are left twisting in the wind. I have a lot of clients who will come and say, oh, well, I gave it to Maureen and she's going to give it to all the other siblings. She might not. I'm not saying you would. No. She might not. You've also potentially created a taxable gift situation
for your siblings.
Yeah. You would have to gift it to them, and you now have a taxable gift. Yep. So you just want to be very kind of strategic with this. And I think that was really the only other ones I want to talk about. But really, the broad stroke is you want to be looking at this as a global project, not discrete tasks of updating this, updating that, and maybe doing this, and so forth. What I love is when the financial advisor who's doing the beneficiary designations calls me after I do the will, and we have a conversation about, oh no, she did want this one account to go just to Maureen because Maureen's going to use that to pay for the funeral or something. Yeah, that's still a trust situation that gets risky, but if it's $10,000 and the rest of the money is going somewhere else, maybe we were okay with that risk. Yeah. Wow. So, that was a lot. I'm sorry.
No, but this is a lot to think about because Heather, I talk to a lot of families who say, oh, I've added my daughter or my son on my account. Mm-hmm. Or I have my will. When was the last time you looked at it? I don't know. Yeah. Do all your loved ones know how to access your documents? Mm-hmm. And this is, I think, Coral, this is a gift. Another one of those gifts we give to family members when we have these unusual conversations, unexpected conversations. These are not sexy conversations.
No, but the more you can have, the families that do best in a crisis, either while mom's alive and ill or after the loved one has passed, are the families that have talked about it at least a little bit. Yes. The more you talk about it, the better they are. The better equipped they are to know if mom really doesn't want to be kept alive on a ventilator. Okay, she really doesn't want that. That gives a clear guidance to your family about what choices to make. But also, the more, there are reasons why we don't maybe want to share some things, but the more we can kind of shine a light on things, it just always makes everyone happier because there's no risk of what's she hiding over there.
Right. Right. Well, and it's part of the your colleague Heather calls it the circles of accountability and support
Yes.
for people, for all of us at any age.
Yes.
To have
team.
this.
Yes.
Yeah, a team. I like that.
Mm-hmm.
And Coral works with a lot of teams.
Mm-hmm.
You know, mine might be her client, but she's working with all the teams around me.
Yes, you're a team member on some of my clients'
Yes.
teams.
So, but it's that important. And you may think, oh, these little bits of information don't matter right now. They do.
Mm-hmm.
So at any age if you're a young adult, if you're middle age, if you're an older adult, please have conversations
Mm-hmm.
with people about where your will is, what the contents are, who the executor is. Make sure the executor is clear on what your wishes are.
At a minimum, where to find it and who your attorney is.
Yes.
I mean, I tell clients, take my signature block and just forward it to your kids, because then they can just search their email. Like, it was something like Van Winkle, and then they find my contact.
Yeah.
You've got to have the ability to figure out what the plan is at some point.
Well, and I have one more question for
Yes.
you, Coral. I know I ask you this personally regularly. How often should people review their wills and or trusts or other tools?
So best practice is every 3 to 5 years, we should be looking at really your whole global package. Who have you named as your healthcare agent? Who is you named as your financial agent? Who is your executor? Who is your trustee? The other trigger point is a major life event.
There we go.
Someone is born, someone dies, someone is diagnosed with a significant disease or disability. You win the lottery, right? Your
Seriously.
financial situation has changed dramatically.
Yes.
You have an inheritance that came in, and you're no longer living off of this pension because daddy left you $3 million. That's a cool problem. Let's figure out how we make sure that it's serving you well. So every 3 to 5 years is best practice, or any major life event. I don't want you to wait 5 years if we just reviewed it, but then your life changed dramatically 2 months later.
And Coral, suppose you move from one state to another. What should be done, if anything?
So if your documents were validly executed in the state from which you're coming, they will be valid in the state you now reside. That is true under the Constitution.
Gotcha.
Okay? Full faith and credit. That being said, there might be other reasons why we want to update things, not least of which is expediency. If I'm going to party and I've got a healthcare power of attorney from Montana, and let's say, well, actually Maryland might be a better example. Sometimes Maryland documents don't require a notary.
Oh, yeah.
All North Carolina documents require a notary. So if I'm taking that to the hospital, they're going to look at this and be like, this doesn't look right. And they might delay the application of that document while they run it through their legal team to make sure it's valid.
Yeah.
I don't want delay in your care or ability for someone to assist you by virtue of just a legal analysis that's happening on the back office. Okay. Similar kind of consideration for a will. Your Florida will is valid here when we probated at the North Carolina clerk of court. I'm pointing because it's technically over there, over my shoulder. But we would have to get an affidavit signed by a Florida attorney attesting to its validity that we also file.
Gotcha.
So we've added now 1 to 2 more documents plus the time to.
That's an expediency issue then.
Right.
Okay.
It's just going to take longer.
Okay.
I have also seen. So this happened with an estate where we had a Maryland will. Maryland does not require a notary, and the court was just. It was a real uphill climb to get them to agree. This is a valid will under the state of Maryland's laws. That may not be true now. I'm not licensed there, but at the time that will was executed, they didn't need to have it notarized. It was a real battle.
Yeah.
And that took us longer to be able to help that person's loved ones because we couldn't even get anyone qualified as executor until the clerk. So there's just considerations about that. Also, if now you own property in 2 states, we would like to have a trust to own that property, right? You lived in Florida, you kept the Florida house, but now you reside in North Carolina. Frankly, it's usually the other one, but we want to title the property that you're not using as your primary residence into your trust. Yeah. You may not have needed a trust before, and now we might have a real reason that we want them.
So it's not just expediency, I think, for you all to have these documents in place and reviewed and regular. There's an emotional piece that goes along with this, particularly in a crisis or upon your death or another member of your family's death. So
I have many clients who come in very, very scared of this process because it's scary to think about our own mortality. And I have not had a single person ever say that they felt worse at the end of the process. They all felt better. I also try to make it at least a little lighthearted because it can be grim.
Yeah.
It doesn't have to be grim.
It's serious.
So we have a serious conversation with levity, and every single time they are happy by the end of the meeting.
So it's worth it. It's worth it. So parting shots, review your documents.
Don't trust everything you hear on a late night commercial.
Yes.
And consult with your own estate planning attorney. This is not, it doesn't have to be me, but I will say there are online programs that purport to create valid wills and trusts. I am not saying that they can't be done, but I will tell you that in all years of practice, I've seen many of those come across my desk, and not one of them has been validly executed or completed. Not one. They forgot to fill something out. I've had some that had big block text that said, like, fill this part in before signing. And they didn't fill it in. It just still said, fill this in before signing. And then it was signed. They're not notarized. They're not witnessed. They're not witnessed by the right people. The notary was the witness. All sorts of things can go wrong. So I don't care who you go to, but at least at this point, I don't recommend an online platform. But consult with your estate planning attorney.
And see a real person. Awesome.
Mm-hmm.
Thank you, Coral.
Thank
She's
you.
always so full of wonderful information. And we hope that you just take just even one pearl of wisdom, one pearl today, one pearl of wisdom today, and look at your documents or think about it or talk to someone like Coral or wherever you live.
Yeah.
Okay.
Yeah.
Thank you. I love it. I love it when Coral joins us. And so if you have any questions for her, you can go to www.bwlawfirm.com. Or if you have any questions for me or Four Seasons, that's 866-466-9734. Or please go to our website. Lots of information. And that is fourseasonscare.org. And thank you very much. And we hope you have a great day.
Thank you.
Coral. Bye-bye.